The coffee in Zurich always smelled different from the coffee in Connecticut. Not better necessarily, just cleaner. There was no sentiment in it, no memory attached to the particular weight of those beans or the specific temperature at which the machine brewed them each morning. That was the point. Marcus Vane had chosen the apartment in Zurich's Seefeld district precisely because nothing in it reminded him of anything. The oak floors were a shade too light. At the ceilings were lower by 4 inches than what he'd lived with for 6 years. The kitchen window faced east instead of west, which meant the morning light came in at the wrong angle, bleaching the countertop in a way that still, 6 months in, registered as slightly foreign to him. He found that useful. He was standing at that window now, a ceramic cup warming his left palm, his right hand resting loosely at his side, but watching the gray-green surface of the Zurich Sea shift under a thin October wind. Behind him, open on the desk he'd positioned to face away from the view. Because he'd learned not to give himself distractions when he needed to think, was his laptop. The screen showed a split feed from 4 security cameras, all of them mounted at the Connecticut property he no longer legally owned but had arranged, through a very specific instrument of corporate law, to monitor for another 14 months. He didn't need to turn around to know what the cameras were showing. He'd watched it happen in real time, 40 minutes ago, when the notification had pulsed on his phone with the quiet efficiency of a system that had no feelings about what it was reporting. Motion detected. Front approach. He'd looked at the screen, seen the silver Mercedes SUV, the one Daniel had bought her as a wedding gift, which Marcus knew cost exactly $212,000 because he'd seen the purchase run through the business account as a client entertainment expense before he'd removed himself from that account entirely. Pull into the driveway that still had the same gray pavers Marcus had chosen in the spring of the year they moved in. He'd watched Vivian cross. Vivian Ashford now, technically, though the name still processed in his mind with a slight cognitive delay, like a foreign word he hadn't fully absorbed. Step out of the vehicle. She was wearing a camel-colored coat, belted at the waist, and her dark hair was down in the way she only wore it when she wasn't going anywhere professional. She'd walked up the front path slowly, not the walk of someone arriving with purpose, the walk of someone who had practiced what they were going to say and were now rehearsing it one final time. She'd knocked. Then she'd knocked again. Then she'd tried the key she still had. The one Marcus had known she still had, and had not asked her to return, because he'd had the locks changed on a Tuesday morning in February, 7 months ago, through the property management company whose retainer he'd prepaid for 2 years running, and because the particular expression on a person's face when a key they believe still works, does not work, was a form of information he'd wanted to exist in the world. Yet he'd watched her stand on the front steps for 4 minutes, the key hanging from her fingers, looking at the door. Then she'd walked around to the side of the house and looked in through the window there, the one that used to face the living room with the stone fireplace and the built-in shelving he'd spent 3 weekends installing himself, while she'd sat on the floor below him, handing up brackets and complaining pleasantly about sawdust in her hair. The shelves were gone, and the fireplace surround was still there, obviously, because you couldn't take a fireplace, but everything else Marcus Vane had ever put in that room was not. The movers had come on a Thursday, worked for 11 hours, and left with a precision that would have been admirable even if it hadn't been planned to the minute. He turned from the Zurich See now and looked at the laptop screen. The camera feed was still active. Vivian was sitting on the front steps, just sitting, and the coat pooled around her on the stone. She was looking at something in her hands. Her phone, probably, though the camera resolution at that distance made it impossible to confirm. Marcus set his coffee down on the window ledge. He looked at her on the screen for a long moment with the same expression he'd been wearing, more or less, for the past 8 months, composed, quiet, and fundamentally absent of the thing that expression was designed to conceal. Not grief, not anger, something colder and more architectural than either. He pulled a chair to the desk, sat down, and began to work. He had met Vivian Cross at a conference in Boston. Not the kind of conference where people met in any romantic sense. It was a 2-day financial litigation seminar, the kind attended primarily by forensic accountants, corporate attorneys, and the specific subspecies of compliance consultant who read regulatory filings for pleasure. Marcus had been 29. He'd been presenting a paper on asset concealment techniques as applied to marital dissolution proceedings, which was either the least romantic topic in the English language or, depending on how you looked at it, a very honest preview of his particular skill set. She'd been in the audience. She was a financial journalist at the time, working for a business publication whose name had some weight in New York circles, attending the seminar because she was researching a piece on forensic accounting's intersection with corporate fraud detection. She'd asked the second question from the floor, and it had been a good question, sharp in the right places, betraying a layperson's intelligence rather than a specialist's jargon. And he'd answered it more fully than he'd answered the first question, which had come from a colleague who should have known better than to ask it. And after the session, she'd waited until the small crowd around him thinned, then walked over without any particular performance of casualness and said directly that she was writing about a specific type of embezzlement case and wanted a source who understood both the forensic and the legal dimensions. She'd handed him a card. He'd looked at it, then at her, and said he was typically selective about going on record. She'd said she wasn't asking him to go on record. She was asking him to go to dinner. He'd appreciated the precision of the distinction. That was 6 years ago. They'd had 3 good years, then 2 years that required work, then 1 year that required more work than Marcus had understood was necessary at the time. And then it ended, not loudly, not with a single moment he could have pointed to later and said there, that was the break. But in the way all structural failures ultimately reveal themselves. The collapse looked sudden, but the cracks had been forming long before anyone thought to look at the foundation. Daniel Ashford had come into their lives at the end of the 2nd year. He was Marcus's business partner in the more conventional sense. They'd co-founded a consultancy together, Ashford Vane Capital Advisory, which provided forensic and strategic services to mid-market private equity firms and family offices navigating distressed acquisitions. Daniel was the face of the operation, magnetic, polished, the kind of man whose handshake felt like a promise, and whose dinner conversations made clients feel they were the most interesting people in the room. Marcus was the architecture behind it, the work, the analysis, the strategies that Daniel then presented in rooms Marcus rarely entered because he found the performance of those rooms tedious. It had been a functional arrangement for 4 years. He'd known about the affair for 11 months before Vivian ended the relationship. And he wanted to be clear about that, at least to himself, sitting now in Zurich with the laptop screen casting pale light across his hands. He'd known for 11 months, and he had said nothing. And he had not been frozen or in denial or any of the other things that might explain that silence if this were a simpler story. He'd known, and he'd begun, quietly, and with the patience of someone who understood that the most durable victories are the ones the defeated party never sees coming, to prepare. Whilst the first indication had not been personal. It had been financial, which was in retrospect entirely appropriate for a man whose professional life was built around understanding that financial patterns told the truest stories about human behavior. He'd been reviewing the quarterly management accounts of Ashford Vane in March, not because anything specific had prompted concern, but because reviewing the accounts was something Marcus did as a matter of architecture. the same way an engineer periodically walks the structure they designed even when nothing has been reported. And he'd noticed an anomaly in the entertainment and hospitality line items. Not a large anomaly. That was the thing people misunderstood about sophisticated financial concealment. It rarely manifested as large anomalies. It manifested as small ones, repeated with a consistency that the perpetrator believed was below the threshold of notice, of $4,100 in client entertainment, recurring roughly every 3 weeks. The vendor listed was a restaurant group in New York, whose name Marcus did not recognize. He cross-referenced it against their client engagement logs and found no corresponding meetings. He checked the credit card statements and found the charge was always on Daniel's corporate card. He sat with that for 2 days. Then he did what he always did when he had a partial pattern and needed to complete it. He gathered more data without disturbing the pattern in progress. He ran a quiet trace on the restaurant group. It was a real establishment, high-end, private dining rooms, the kind of place couples went when they did not want to be seen by people they knew. He obtained through a contact in the restaurant's accounting firm who owed him a professional courtesy and a general description of the booking pattern associated with the corporate account. Regular table for 2. Same booking name. Daniel Ashford's name. Marcus had then pulled Vivian's personal calendar. They'd shared a digital calendar for 4 years, a domestic convenience neither of them had ever thought to question, and looked at the dates. The correlation was not perfect, which was what had kept him still for a moment before the arithmetic completed itself. She used a secondary calendar. Well, clearly. One he wasn't shared on. He knew this because he'd already run the overlap and found that on 7 of the 11 dates the restaurant charges appeared, Vivian's primary calendar showed her as in transit or working late, or simply blank. He'd closed the laptop. He'd stood in the kitchen of the Connecticut house, the same kitchen whose window now looked out at nothing because the curtains he'd chosen had been removed and packed, and he'd drunk a glass of water. Then another. He'd felt something move through him that he did not give a name to. It was too structured to be grief, and too quiet to be rage. It felt, if he were to describe it accurately, like the moment in a forensic investigation when the data stops being ambiguous and starts being conclusive. The feeling was not satisfaction exactly. It was closer to the particular stillness that follows a very long question, finally becoming an answer. He did not call Daniel. He did not confront Vivian. And he did not change his behavior in any way that would signal the alteration that had occurred inside him. What he did the next morning was call Reese. Reese Calloway had been Marcus's attorney in the professional sense for 6 years, but in the more accurate sense, he was the one person in Marcus's life who understood both the forensic and the strategic dimensions of the way Marcus operated. They'd gone to law school together. Marcus had left practice after 5 years to move into advisory work, while Reese had stayed and become, quietly, and without any of the publicity he could have generated if he'd wanted it, one of the most effective corporate attorneys in the Northeast. He worked out of a second-floor office in New Haven that looked like it belonged to a mid-level family law practice and had the functional output of a major firm's M&A department. Marcus had driven to New Haven on a Thursday morning and arrived at Reese's office before his first appointment. And he'd sat across from Reese at the cluttered desk, papers everywhere, 3 different colored sticky note systems operating simultaneously, a coffee from a diner down the street that Reese drank cold every morning because he always forgot about it, and explained what he'd found and what he suspected with the same cadence and structure he'd use presenting findings to a client. No emotional texture. Just the data and its implications. Reese had listened without interrupting, which was a professional habit Marcus had always valued in him. Then he'd said, "You want to know your exposure?" I want to know my options. Reese had taken a legal pad and started writing. Not for Marcus's benefit, Reese always thought with a pen in hand. Okay, the business first, because that's actually the most important piece. You've got the operating agreement from when you incorporated. What does it say about dissolution? Standard buy-sell provisions. And either partner can trigger a buyout at a formula valuation based on trailing 12 months' revenue. Who drafted it? I did. Reese had looked up from the pad. With the standard carve-outs? With the specific carve-outs we discussed in 2019 when I came to you about updating the structure. A small smile had moved across Reese's face, the particular expression of a man who appreciated professional foresight. Well, the ones that allow you to trigger the buy-sell, but defer the payment obligation for 18 months if you can demonstrate a material breach of the partnership's fiduciary duty. Which is what's been happening. What's been happening, Reese said, is that Daniel has been using the business account for personal expenses. That's a clear fiduciary breach. Whether it's also something else depends on the amounts and the pattern. He tapped the pen against the pad. How much are we talking? A total? I pulled everything this morning before I drove here. If the restaurant charges are what I think they are, and I run the same analysis on the other anomalous line items, there are 4 other recurring items that don't have corresponding client records. We're looking at somewhere between $80,000 and $115,000 over 2 years. The pen stopped tapping. That's not an accounting error. No, that's embezzlement. That's embezzlement, Marcus confirmed, yet with the same tone he'd use confirming a quarterly figure. What followed was a 4-hour conversation that Marcus afterward always characterized simply as the meeting where the architecture was designed. Reese walked through the corporate structure, the personal assets, the real property, the investment accounts, the exposure on every side. He was meticulous in the way that only people who had spent their professional lives watching other people's failures of preparation could be meticulous. Dusut he found 3 things Marcus had not anticipated, which was why Marcus paid him. He also confirmed 12 things Marcus had anticipated, which was why Marcus had called him. By the time Marcus drove back to Connecticut, he had a structure. Not a plan, exactly. Plans were reactive documents, and what Marcus had built with Reese was not reactive. It was anticipatory. It was a framework designed to function correctly regardless of how the other parties behaved. Because the most durable legal and financial strategies were the ones that didn't require the opposition to make a specific mistake. They simply required time and the consistent application of correct mechanics. He'd gone home that evening. Vivian had made pasta. He'd eaten 2 servings and told her it was excellent, which it was. They'd watched something on television, a documentary about deep-sea architecture, which she'd chosen and which he'd genuinely found interesting. And when they went to bed, she'd fallen asleep with her head at the edge of his shoulder, in the half-arrangement that had been their default for years, and he'd lain awake looking at the ceiling for approximately 20 minutes before his own professional discipline asserted itself, and he filed the emotional weight of the evening in the appropriate internal space and closed his eyes. He slept 7 hours. And he always slept well when he was working. The legal and financial restructuring took 4 months. Marcus moved through it the way he moved through any forensic engagement, methodically, without urgency, and without announcing his intentions through the sequence of his actions. The first instrument he executed was the most important one. Under the Ashford Vane operating agreement, the one Marcus had drafted in 2019 with Reese's input, which Daniel had reviewed for approximately 40 minutes before signing, because Daniel trusted Marcus's legal work in the same comprehensive way that people tend to trust the expertise of those they are simultaneously betraying. The partnership structure included a provision that allowed either partner to convert their ownership interest into a separate holding entity without triggering a dissolution event, was provided the conversion was completed before either partner had issued a dissolution notice. It was a provision that served a legitimate tax planning purpose and that Daniel had nodded at when it was explained to him, and then entirely forgotten. On a Tuesday afternoon in April, Marcus transferred his 49% ownership interest in Ashford Vane Capital Advisory into a Delaware Series LLC that Reese had incorporated 3 weeks earlier. The LLC was owned by a trust, yet the trust's beneficiary was Marcus. The structure was not designed to hide assets. It was entirely transparent to any competent forensic review, which was precisely the point, because Marcus had no interest in anything that could be characterized as concealment. The structure was designed to insulate, to create a legal distance between his ownership interest and any future claim that might arise from a dissolution, a creditor action, or the kind of litigation that tended to follow when one partner in a small advisory firm was eventually confronted with an embezzlement finding. He wasn't hiding. He was positioning. The real estate was more straightforward. The Connecticut house was owned jointly, a common error in the architecture of shared lives, the assumption that joint ownership was an expression of commitment rather than a legal arrangement with specific implications, as Marcus had been on the deed since they'd bought the property. Vivian's name had been added 2 years later, at her request, as a gesture of permanence that Marcus had agreed to, because at the time it had seemed like the correct thing to do, and because he'd been, at the time, genuinely committed to the architecture of that particular future. Under Connecticut law, once a joint tenant with right of survivorship can sever the joint tenancy by conveying their interest, without the other joint tenant's knowledge or consent, to a third party, which reconstitutes the ownership as a tenancy in common, eliminating the survivorship feature. Marcus had severed the joint tenancy in May, conveying his 50% interest to the Delaware Trust, which then simultaneously conveyed it back to him as a tenant in common. It was a technical maneuver, entirely legal, but entirely documented, and designed to ensure that if the property became contested, which he anticipated it would, eventually, depending on how events developed, his position would be clearly defined and defensible. He'd also, in the same month, retained a separate property management firm and prepaid a 2-year management contract, which included the authority to execute a lock change at any time without additional authorization from the property owner. And he'd notarized the instruction in advance. The lock change was to be executed on the first business day of August, regardless of any contrary instruction from any party other than Marcus Vane directly. August was the month he'd calculated he'd be gone. The financial accounts were the most technically complex component. Marcus and Vivian had 2 joint accounts, a household operating account and a savings account they'd nominally used for travel, whilst the operating account had his salary direct deposited into it, which required a change of instruction to his bank. He redirected his direct deposit to a personal account held solely in his name, which he'd opened in March at a different institution. He began drawing down his share of the joint savings, 50%, transferred in 4 tranches over 8 weeks, all documented, all compliant with the account terms, was all categorized in his own records with the specificity required by someone who expected that documentation to be reviewed by a court at some point in the future. He left Vivian's half untouched. This was not generosity. This was calculation. A man who strips a joint account entirely creates a narrative about himself that is useful to the opposition. A man who takes only his half, documented correctly, creates a narrative that is boring and unassailable, Marcus had spent enough time as an expert witness in financial litigation to understand that the facts of a transaction mattered less than the story those facts allowed each side to tell. He was not interested in stories that could be contested. He was interested only in facts whose implications were unambiguous. The investment portfolio was more nuanced. He'd had 2 accounts at a private wealth management firm. One personal, one that functioned as a commingled domestic asset, and the commingled account was the one that required the most careful handling, because commingled assets in a relationship that hadn't legally constituted a marriage were subject to a specific set of equitable arguments that could go several directions depending on the judge. Reese had spent 6 hours on this particular component. What the conclusion they'd arrived at was architecturally elegant. Marcus would not liquidate or transfer the commingled account. He would instead instruct the wealth management firm to freeze new contributions and document the account's current balance as of a specific date, creating a clear watermark. Any appreciation or diminishment from that date forward would be attributable to market performance rather than either party's contribution. And Marcus would begin building a separate personal account at a different institution that Vivian had no visibility into, which would receive all of his professional income going forward. By July, his financial fingerprint in the shared life had been reduced to the residual. He was still there, technically. He still deposited a nominal amount to the household account each month, a fraction of his previous contribution, enough to maintain the appearance of normalcy, and he still received mail at the Connecticut address. He still came home most evenings, ate dinner, slept in the same bed. He was very good at coming home most evenings. The forensic documentation of Daniel's embezzlement was a separate work stream running parallel to the personal restructuring, and it was the one that Marcus found most technically interesting because it required him to operate as both the investigator and the subject, not of the investigation, but of the relationship that gave him access to the information he was investigating. He'd built the evidentiary file over 4 months. Not a rushed collection of screenshots or printouts, but a structured forensic record of the kind that would stand up to a professional audit review and, if necessary, support a criminal referral. Every transaction he'd identified as anomalous was documented with its source data, its vendor trace, the corresponding absence of a matching client record, and a brief analytical note explaining why the transaction could not be categorized as a legitimate business expense under any reasonable standard. The total came to $108,400. 37 discrete transactions over 22 months. The average transaction size was designed to stay under the threshold most automated internal controls flagged. Daniel had been careful in that specific way. He'd been less careful in the overall pattern, but that was typical. People who committed financial misconduct were almost always careful about the trees and completely blind to the forest. Marcus had documented the forest. He'd also, and this was the part he considered the most structurally interesting piece of the work, obtained independent corroboration for 6 of the transactions. Not by asking anyone, not by involving anyone who might speak to Daniel or Vivian before he was ready, but by pulling publicly available records, reservation confirmations that had been forwarded to the business email account, expense report attachments that Daniel had filed without redacting location data from the metadata, a vendor invoice that had been paid and then disputed, and whose dispute correspondence was accessible through the business account portal. He'd assembled the complete file and given a copy to Reese in June, with a cover memo that said only, "To be filed with the relevant authorities upon my instruction. No action until I instruct." Reese had looked at the file for 20 minutes, then looked up and said, "When do you want to instruct?" "After the wedding." "Why after?" Marcus had thought about how to answer that accurately. Because I want the structure of his life to be fully committed before the foundation is removed. If I move now, he can extricate. If I move after, he can only fall. Reese had nodded slowly, in the way he nodded when he was deciding not to ask the follow-up question. And Vivian? I want her to be in the house when it burns, Marcus said, not standing outside deciding whether to go in. He'd meant it financially. He wanted Vivian to have already legally and publicly committed to Daniel Ashford, to have married him, to have her name on the documents, but to have whatever social and financial calculations she'd made be fully executed, before the information about what kind of man she'd made those calculations about became available. Not because he wanted to destroy her, because he wanted her to be the one living with the consequences of her own arithmetic. The engagement was announced in May on a social media platform that Marcus had always found theoretically interesting as a behavioral artifact. Just the photograph was predictable. The ring in the foreground, their faces slightly blurred behind it in the way that was intended to look spontaneous and had clearly been staged, the caption the kind of sentence that communicated nothing specific while performing a great deal of public emotion. Mutual friends sent Marcus messages. Some were awkward. Some were more awkward. A few were precisely calibrated attempts to determine how Marcus was taking it, which he recognized as a specific social genre and appreciated for what it told him about the sender's loyalties. He replied to all of them with sentences of between 15 and 30 words. Composed. Warm in a professional sense, revealing nothing. He had been composing his responses to the engagement announcement since March, when he'd assessed it as a near certainty, so by the time it occurred he had already processed the anticipation of it and was operating in the after. He saw Vivian twice between the announcement and the wedding. Both times in the Connecticut house. She'd kept clothing there, kept the pretense of checking on him, which Marcus understood was performing several functions simultaneously. She wanted to ensure he was not doing anything destabilizing. She also, he suspected, wanted the comfort of confirming that he was fine, because it is easier to proceed with a decision when the person you're proceeding away from appears to be intact. He was both times entirely intact. He made coffee. He asked about the wedding preparations with the interested affect of a distant friend. He listened to her answers with his full attention, which had always been one of the things she'd said she valued about him. That when Marcus listened, he actually listened, not in the performative way of someone waiting for their turn, but in the focused way of someone who intended to use what they heard. He used what he heard. The second visit. She'd stood in the kitchen looking at him with an expression he'd catalogued as something between guilt and the discomfort of not finding what she'd expected to find. He didn't know exactly what she'd expected. Something cracked, perhaps. Something that would retrospectively justify the decision she'd made by demonstrating that he had never truly been enough. Not emotionally, of course, not in the ways that the word meant in the conversations she'd been having with herself about this, for whatever period it had been developing before he'd noticed. He'd handed her a coffee and asked if she had a florist yet. She'd said yes. He'd said that was good, that logistics at the last minute were stressful. She'd agreed. He'd nodded. She'd left 40 minutes later looking more unsettled than when she'd arrived, and Marcus had washed both cups and gone to his desk and called Petra. Petra Solis had been his executive assistant for 3 years, technically the firm's assistant, but in practice, the person who managed the operational texture of Marcus's professional life with the quiet efficiency of someone who understood exactly what she was working with. She was 27, worked remotely from Austin, and had a cognitive relationship with complex scheduling and documentation logistics that Marcus had recognized immediately as rare. as he'd called her to brief her on the timeline for his physical relocation. The apartment in Zurich had been secured in March through a corporate relocation service. He'd used a business address, not a personal one, because business relocations were tidier and attracted less inquiry. The moving company had been contracted and briefed. The storage arrangements for the items he was keeping were finalized. Petra had coordinated the professional transition. Ashford Vane Capital Advisory would continue to operate because Marcus had no interest in disrupting it precipitously. The disruption would come through the correct legal channels at the correct time. And he was temporarily reducing his visible operational involvement due to a personal sabbatical that Petra had communicated to their client base with a warmth and professional confidence that meant no one asked many questions. And he'd briefed her on 2 more things that call. The first was the security system at the Connecticut house, a camera and monitoring arrangement that Reese had confirmed Marcus could maintain under his legal capacity as a co-owner on 30 days' notice to the property management firm, for as long as his ownership interest remained active, which, under the structure they'd designed, was indefinitely, or until a court said otherwise. The second thing he briefed her on was the wedding gift, and he'd sent it 3 days before the ceremony. A physical envelope, courier delivered, addressed to Daniel Ashford at the business address. The card inside had said, in Marcus's handwriting, "Congratulations on the new beginning." Inside was a single document, a copy of the buy-sell notice he'd already filed with Reese, triggering the partnership dissolution under the material breach provision, one with a footnote indicating that the formal forensic audit report had been submitted to Reese's office and would be transmitted to the relevant regulatory bodies on the first business day following the wedding. Daniel would not have fully understood what he was reading at first. He'd understand it eventually. By the time he understood it fully, Marcus would already be in Zurich. The movers had come on a Thursday in late July, 11 days before the wedding that Marcus had not been invited to and would not have attended regardless. They'd worked from 7 in the morning until 6 in the evening. And when they left, the Connecticut house was not empty in the desolate sense, not stripped to the bare plaster, but emptied of Marcus. The furniture that had been his choice, his purchase, his specific material signature in that space, gone. The shelves he'd built, dismantled and packed. The specific objects, books, certain artwork, the kitchen equipment he'd bought with the rigorous personal attention he applied to anything he used daily, packed and shipped. What remained was Vivian's furniture, Vivian's things, and the structural elements of a house that now held the particular quality of a space that has had a portion of its contents removed. Not empty, hollowed. He'd driven to JFK that Thursday evening and taken an overnight flight to Zurich. He'd sat in the window seat of the business cabin with a glass of water and his laptop and worked for 4 hours on a client engagement that had nothing to do with any of what he'd left behind. And then he'd reclined the seat and slept, with the thoroughness of someone whose work was complete and who had learned over a professional lifetime not to carry the weight of finished things into the next phase. As he'd landed in Zurich on a Friday morning when the Alps were doing something particular with the low autumn light, making the whole approach into the city look like a painting executed with somewhat theatrical ambition, and he'd taken a cab to the apartment in Seefeld and stood at the window facing the Zürichsee and felt, very precisely, nothing that he needed to manage. The wedding was on a Saturday in early August, 12 days after Marcus left the country. And he knew this because Petra monitored the social media coverage with the detached efficiency of someone running a media tracking report, which is how she had characterized the task in her time billing system. She'd sent him a summary email on Sunday. Event appeared to proceed as planned. Approximately 240 guests. Venue was a restored estate property in Litchfield County. Coverage consistent with expectations. Marcus had read the email, filed it, and called Reese. The filing goes today, he'd said. I already sent it, Reese said. Technically, it went at 9 this morning, when the SEC's online submission system opened. The forensic report and the full documentation? Everything. 122 pages. I also transmitted a copy to the compliance officer at their primary institutional client, because the terms of that client's engagement contract include a self-reporting obligation for any partner-level fiduciary issue. A pause. That one will take a few days to filter through. The SEC acknowledgement came back within the hour. Marcus had said thank you and ended the call. He'd made coffee. Zurich coffee. Clean and present tense, and sat at the desk he'd positioned away from the view and continued working. The institutional machinery of a financial misconduct investigation has its own temporal architecture, which Marcus understood precisely. The SEC receipt was an acknowledgement, not an action, and the action would come after their internal review, typically 4 to 8 weeks, for an initial assessment of whether the matter warranted a formal inquiry. The parallel track, the civil litigation that would arise from the partnership dissolution and the buy-sell trigger, would move slightly faster because it had a private party driving it rather than a regulatory body. Reese filed the civil suit 3 weeks after the wedding. As the suit named Daniel Ashford individually and Ashford Vane Capital Advisory, LLC, as defendants, alleged breach of fiduciary duty, misappropriation of partnership assets, and sought damages of not less than $340,000, which included the documented embezzlement amount, Marcus's estimate of the business value diminishment attributable to Daniel's misconduct, and legal costs. It also triggered the formal dissolution process and the buy-sell mechanism, which required an independent valuation of Marcus's partnership interest. The valuation, conducted by a firm that Reese retained and that had no relationship with Daniel or any of his professional contacts, came back at $820,000. Under the operating agreement's material breach provision, the one Marcus had drafted with the specific carve-out that allowed the payment obligation to be deferred for 18 months if a fiduciary breach was demonstrated, Daniel was required to pay Marcus his full valuation amount within the 18-month window or face a default judgment. Daniel did not have $820,000 in liquid assets. Marcus knew this because he'd reviewed the company's accounts in detail before structuring the valuation formula. What Daniel had was a mortgage-encumbered house in Westport, the silver Mercedes SUV he'd given Vivian, a personal investment account that Marcus estimated at $300,000 based on several years of observing Daniel's spending relative to his income, and his share of the ongoing revenues of a consultancy that was now in formal dissolution proceedings and whose primary institutional client had, 11 days after the SEC filing, quietly placed the firm on administrative hold pending the resolution of the compliance inquiry, which meant the revenues had stopped. He'd been in Zurich for 6 weeks when the first call came from Vivian. It came to his personal phone, the same number she'd always had for him, because he hadn't changed it, and he'd looked at the screen when it lit up, held it for the 4 rings it took for the call to go to voicemail, then listened to the message. Her voice had a quality in it he hadn't heard before. Not distress, exactly. She was too composed for that, too practiced at controlled presentation, but a tightness that his ear registered as the sound of someone who has recently received information that has altered the architecture of what they thought they were standing on. She said she was just checking in. She said she wanted to make sure he was okay. She said she'd stopped by the house, and it looked like he'd moved some things out. And she just wanted to make sure everything was all right. And could he call her when he had a chance? He had not called her. 2 days later, she called again. The tightness in her voice was slightly more pronounced. She said she'd heard there was some kind of legal matter with the firm. She said Daniel had mentioned it. And she said she was sure it was all just a misunderstanding. These things happened in business. And she really did just want to make sure Marcus was okay and that they could talk. He had not called her. The third call came 10 days after the second. This one was different. She didn't ask him to call back. She said she was going to come to the house on Saturday. She said she still had a key, and she just wanted to come and talk, because she felt like there were things that needed to be said. And she was going to be there at 2 o'clock. He'd listened to that message 3 times, not because of what it said, but because of what it revealed about her model of the situation. She believed the house would still be full. She believed she would arrive to find the evidence of his continued presence, his books, his shelves, his particular material density in a space, and that the conversation she was rehearsing would take place in a context that confirmed, at least ambiguously, some version of continuity. She still had a key. She was going to come. He'd thought about that for a long time, in the way he thought about strategic inflection points, not with calculation exactly, because the calculation had been complete for months, but with the particular attention he gave to moments that would be, for all parties, definitional. He'd confirmed with the property management firm that the locks had been changed in August as instructed. He'd confirmed with Petra that the security camera system was active and recording. He'd confirmed with Reese that his status as co-owner was still legally active and that his decision not to be present was consistent with his property rights. Then he'd arranged his Saturday in Zurich. A long run along the lake in the morning, a lunch at a restaurant near the university district that he'd been meaning to try since his first week, some work in the afternoon, in at the desk that faced away from the view. He'd be at the desk, probably, when she arrived. She arrived at 2:07 on a Saturday in October. He'd seen the Mercedes SUV on the camera feed from his phone at first, and then had moved to the desk and opened the camera system on the laptop with the larger screen, because he wanted to see it properly. The resolution was good. He'd invested in a camera system whose resolution was good. She was wearing the camel-colored coat. Her dark hair was down. And she knocked twice on the front door, with the particular knock of someone who had rehearsed arriving. 3 knuckles and a pause. She waited 30 seconds. She knocked again. The key went in. It turned, in the way keys turn in locks they no longer fit, approximately a quarter rotation before meeting resistance and stopping. He watched her pull it out, look at it, try again. Watched her hold the key at her side for a moment, yet watched her look at the door the way people look at objects that have failed them, not with accusation exactly, but with the particular blankness of recalibrating. She walked around to the side of the house. He switched to the side camera, the one that had the best angle on the window that used to face the living room. She stood at the glass and looked in. He couldn't see her expression at this resolution, at this distance, but he didn't need to. And he knew the room she was looking at. 4 walls, a stone fireplace surround, afternoon light on a floor that had no shelves above it, no books, no rugs, no particular human claim on the space. She stood there for 94 seconds. He knew because he counted them. Then she walked around to the front of the house again and sat down on the front steps. The coat pooled around her. She was looking at her phone. She would be looking for his contact. She would be calling or texting. One final time, and into the silence. He did not pick up his phone. He looked at her on the screen. This woman he had loved with the specific structural seriousness he brought to things he committed to. This woman who had weighed what they'd built against something else and found the something else more compelling. This woman who had come to comfort him and found instead the architecture of his answer. and he felt, with precision, was the thing he'd been carrying for 8 months release itself in the quiet and specific way of a mechanism completing its function. Not relief, not satisfaction. Something simpler. The feeling of a thing being finished. He reached forward and closed the camera window on the laptop. He opened the client file he'd been working on before the notification had come through. He found his place in the analysis, read the last paragraph he'd written to re-enter the thinking, and continued. The SEC formal inquiry notice arrived at Ashford Vane's registered address in November. By that point, the firm had no operational staff. Petra had managed an orderly wind-down of the support functions in September, and the remaining client relationships had been transferred to partner firms with Marcus's personal recommendation and without incident. The inquiry notice was forwarded to the law firm Daniel had retained to handle the matter, which was a mid-size litigation boutique in Manhattan that Marcus knew by reputation and assessed as competent but not exceptional. What the inquiry notice meant, practically, was that the SEC was treating the initial filing as warranting a formal investigation. This triggered specific disclosure obligations under securities law. Daniel was required to notify his broker-dealers, any registered entities he was affiliated with, and his professional liability insurer. Now, as the insurer's response to that notification was, in Marcus's estimation, entirely predictable. They reviewed the documentation, noted the concurrent civil litigation, and issued a reservation of rights letter indicating that coverage for the alleged conduct might not apply under the policy's intentional acts exclusion. Without insurance coverage, Daniel was exposed to the full amount of the civil judgment personally. Reese had called Marcus with that development on a Tuesday evening, Zurich time. Hunt, which was early afternoon in New Haven. Marcus had been making dinner, a pasta dish, because it was one of the things he'd always genuinely enjoyed cooking, the specific attentiveness required to time multiple components correctly. He'd held the phone between his ear and his shoulder and listened to Reese walk through the implications. "He's going to have to liquidate to satisfy the judgment," Reese said. "If the SEC inquiry escalates to enforcement action, and I think it will based on what we submitted, there's a personal financial penalty exposure on top of the civil damages. He might also be looking at disgorgement of profits from transactions he executed during the period the misconduct was occurring." "The Whitmore deal," Marcus said. He meant a specific acquisition transaction they'd advised on in the previous year, during the period the embezzlement was documented. "That's the one I'd flag, yes. So if he personally benefited from advisory fees on transactions where he was simultaneously misusing partnership funds, there's a disgorgement argument." Marcus stirred the pasta. "What's his realistic position?" "Liquidation of the Westport house, assuming the mortgage leaves him with equity. The personal investment account. Possibly the vehicle, though that's small. If the SEC gets to enforcement, he's also looking at a bar from the industry. Which means his earning capacity in this field goes to zero for whatever period they impose." There was a pause. Marcus tasted the pasta, adjusted the heat. "And Vivian?" he said. Reese was quiet for a moment. "Depends on how community property arguments apply, and they're in Connecticut, so it's equitable distribution. If she had no knowledge of the misconduct and didn't benefit from it, she has a strong argument to separate her exposure. Ganto, she'd probably come out with her personal assets intact, but no claim on what he's losing, and whatever they accumulated in the marriage is going to be subject to the dissolution proceedings. They've been married 4 months. Then there's not a lot to distribute either way." Marcus finished cooking and ate at the desk, looking out at the dark of the Zurich Sea, catching the lights from the opposite shore. He thought about Vivian sitting on the front steps of the Connecticut house, with her useless key and her phone and her camel-colored coat, the afternoon light already thinning in the way it did in October before it gave up and became winter, and he thought about all the things she'd weighed and chosen and committed to, with the confidence of a person who believed they had correctly assessed the positions. He thought about that for a while. Then he washed his plate, brushed his teeth, and then slept 7 hours. The civil judgment came in January, 6 months after Reese had filed. It came by default because Daniel's legal team had engaged in a series of procedural delays, extension requests, discovery disputes, a motion to dismiss on grounds that the court dispatched in a single paragraph that had ultimately only served to demonstrate the absence of a substantive defense. The judge awarded Marcus the full valuation amount, plus interest, plus legal costs, plus an additional amount in punitive damages that reflected the court's assessment of the deliberateness of the misconduct. The total judgment was $1,140,000. Daniel's attorneys filed a satisfaction bond, which meant they were formally acknowledging the judgment and committing to satisfy it from identifiable assets. The identifiable assets were the Westport house, sold in March, netting $380,000 after the mortgage. The personal investment account at approximately $290,000 as of the date of the judgment, and a partial payment from the liquidation of Ashford Vane's remaining assets. That brought Daniel to approximately $750,000 toward a judgment of $1,140,000. The SEC enforcement action, when it arrived in February, and added a personal penalty of $200,000, a disgorgement order of $61,000, and an industry bar for 7 years. The gap between what he owed and what he had was $391,000. Marcus was not certain that would ever be collected in full, and he'd told Reese as much. Reese had pointed out that unpaid judgments accumulate interest, appear on credit reports, and follow a person through every financial transaction they attempt for the duration of their enforceability period, which in Connecticut was 20 years with options to renew. Marcus had said that sounded about right. In March, Marcus was in London for 4 days on a client engagement, a private family office navigating a complex acquisition with disputed ownership representation in one of the target's subsidiaries, which was the kind of problem he'd always found more interesting than it was fashionable to admit. He was staying at a hotel near Mayfair, a place with small rooms and good coffee and a reading room off the lobby that he used in the evenings, and he was in the reading room on his second evening when his phone showed a message from a number he recognized as Vivian's. He looked at it for a moment before opening it. She'd written, "I know you're not going to respond to this. I don't really need you to. I just want you to know that I understand what happened. Not all of it, but enough. And I want you to know that I don't think I deserved the version of this that I got. Even if I deserved some version of it, I hope you're somewhere good." He read it 3 times, not because it required 3 readings, because he was giving it the attention it was owed. Then he set the phone face down on the table and looked at the reading room, its dark wood shelves, its lamps with their particular warmth, the couple across the room who were sharing a bottle of wine and reading separate books and not talking and looking entirely comfortable with that arrangement. He thought about what she'd written, about the specific grammar of it, the way it was constructed, not an apology exactly, not a justification, but a kind of inventory. I understand what happened. Not all of it, but enough. It was, he thought, and the most honest thing she'd said to him in perhaps 2 years, and it was said into a void she'd correctly assessed he wouldn't answer. He considered whether it changed anything. He held the question with the professional seriousness he applied to questions that deserved it. It changed nothing in the external architecture. The judgment was entered. The dissolution was complete. His financial position was intact, and, given the settlement proceeds and the professional income he'd continued to build through the Zurich operation, considerably stronger than it had been when they'd shared a kitchen in Connecticut. His professional life had continued its quiet accumulation of complexity and expertise, undisturbed by any of the events of the past year. But he held the message a moment longer before he picked the phone back up, because Vivian had been, before she'd been anything else, the person who'd handed him coffee cups at a conference and asked a good question from the floor and then said precisely what she meant when she handed him her card. And whatever had happened to that person, the pressures, the calculations, the slow accretion of dissatisfaction or ambition, or some feeling she'd never been able to articulate to him clearly enough, she'd been real. The early years had been real. He was not the kind of man who revised history in the service of current feeling. He'd loved her. He'd loved her correctly, with the specific commitment and attention that was his nature. And she had weighed that love against other things and chosen differently. He could hold that as a fact without it requiring either forgiveness or continued bitterness. He was not a man who did bitterness. Bitterness was the emotional equivalent of paying interest on a debt you'd already settled. He picked up the phone and typed 4 words. "I'm somewhere good." "Yes." He sent it. Sure. He set the phone down. He went back to the client file he'd been reviewing before her message had come through and spent another 40 minutes on the ownership representation question before deciding he needed to sleep on the structure before committing to a recommendation. He slept on it. He woke up the next morning with the structure clear in his mind, the way things always became clear after he'd given them time to settle, and he wrote his recommendation before the hotel's coffee had finished brewing, in the clean, early light of a London morning that held nothing he recognized and required nothing from him except his best thinking. He gave it that. The Connecticut house sat on the market for 7 weeks before it sold. Marcus had instructed the property management firm to list it in April. His co-ownership made this legally straightforward, and had engaged a real estate attorney in Hartford to manage the sale proceedings. The property attracted 3 offers, the highest of which was 4% over asking, which the Hartford attorney characterized as a strong result for the current market. Marcus had agreed. He'd instructed the attorney to accept and close as quickly as the buyer's financing allowed, and he'd received his 50% share of the net proceeds after the mortgage satisfaction, the agent's commission, the attorney's fees, and the property management firm's outstanding balance in the form of a wire transfer to the Delaware trust account in May. The amount was $472,000. He had not told Vivian he was listing it. She had received notice, as required, from the real estate attorney in her capacity as co-owner, and she had chosen not to contest the sale. He didn't know whether that was because she'd consulted an attorney who told her contesting it would be expensive and unlikely to succeed, or because she'd made some quieter calculation about the cost of continuing to fight against someone who had already demonstrated the specific character of his preparation. He didn't particularly need to know. Reese had called him on the day the sale closed. "Congratulations on the clean exit from the Connecticut chapter," he'd said, in the dry tone he used when he was being genuinely warm. Marcus had said, "I never particularly liked Connecticut." "You built shelves there." "I built shelves everywhere. I find it useful." "Right." Reese paused. "How's Zurich? Clean? I mean, are you—" Another pause. "How are you, Marcus?" He'd looked at the Zurich Sea, which was doing something different in the May light than it had done in October. Brighter, less contained, the way water looks when it's stopped remembering winter. He thought about how to answer accurately. "I'm working," he said. "The work is good. The engagement in London led to 2 referrals, one of which is quite interesting. I've been running every morning. That's not what I asked. I know. A longer pause. Zurich sounds in the background of his end of the call. A tram going by, someone laughing somewhere below the window. I'm intact, Marcus said. That's an accurate answer. All right, Reese said. And Marcus could hear in those 2 words that it was enough. Not sufficient exactly, but the kind of enough that a person who knows you gives when they recognize that what you've said is the complete truth, and that pressing for more would be asking you to perform a feeling rather than report one. Thank you, Marcus said, for all of it. That's what I do, Reese said. And they both understood that was not a deflection, but a precise statement about the nature of their arrangement, which had always operated on a kind of unspoken mutual respect for professional competence as its own form of care. In June, a former colleague sent Marcus an article from a financial industry publication. The article was a reported piece on the SEC enforcement action against Daniel Ashford. Was written in the dry register that industry publications used when covering misconduct. They were careful not to sensationalize. It named Daniel, described the nature of the misconduct, listed the penalties, and noted the 7-year industry bar. It mentioned, in the 3rd paragraph, that Ashford Vane Capital Advisory had been dissolved as of the previous January. It did not mention Marcus. He'd read the article once. He returned it to the email thread with a brief note to his colleague, "Thanks for sending," and filed it. Later that evening, he'd been running along the Zürichsee in the particular June light that made everything around it look slightly more deliberate than usual. The water and the mountains and the sky all operating with an attention to composition that was either natural or his own projection. And he'd thought about the article and what it represented in the totality of the thing. He'd built something. He'd done it correctly, with a partner he'd trusted and with a woman he'd loved, and both the partner and the woman had made choices that demonstrated they'd understood neither the depth of what they'd been given nor the specific quality of the man who'd given it. And he'd lost the thing he'd built, the partnership, the house, as the particular domestic architecture of that life, not through failure or weakness, but through the simple fact that you could not force other people's choices. But he'd built it once. He could build it again. He understood the mechanics now in a way he hadn't at 29. Not just the professional mechanics, the contracts and the structures and the instruments, but the personal ones. The specific places where he'd failed to see what was forming was not because he lacked the skill to see it, but because he'd been choosing, perhaps, not to look. The particular error of a man who spent his professional life reading patterns and chose, in the one context that mattered most, to treat the absence of evidence as evidence of absence. He'd run 6 miles that evening, which was a mile more than usual, and arrived back at the apartment with the specific clear-headed exhaustion of physical effort, and sat at the window he'd positioned to face the lake. He'd moved the desk, at some point in March, to face the view, because he'd realized that the gesture of facing away from it had been an austerity measure he no longer needed, and watched the late light break into pieces on the water. He'd thought, with the professional honesty he applied to post-engagement reviews, what was the lesson? But not in the sentimental sense, in the architectural sense. What was the thing that would make the next structure more durable than the last? He'd thought about it for a long time. The conclusion he arrived at was not original, but it was, for the first time in his life, genuinely his. The most important forensic work was not the kind you did after the damage was apparent. It was the kind you did in the middle of building, not to find evidence of betrayal, because that was already too late, but to maintain the honest accounting of the actual texture of the thing you were building. Whether the foundation was real, whether the load-bearing elements were genuine or decorative, whether the other person in the structure was building the same thing you were, or something adjacent that only appeared the same from certain angles. He'd known, if he was being fully honest with himself, for longer than 11 months. He'd known in the way you know when a piece of analysis is going to come out wrong, and you keep running it anyway because you've already committed to the outcome it was supposed to support. He'd known, and he'd proceeded, and that was his portion of the failure. Not the majority of it, but a portion. And a man of his particular professional formation had no patience for the comfort of excusing his own portion of a failure because someone else's was larger. He filed that assessment with the same care he filed everything. Not for punishment, not as a weight to carry, but as data. Useful for next time. In September, 14 months after he'd arrived in Zurich, Marcus opened a new client engagement that required him to spend 3 weeks in Singapore and 2 weeks in Hong Kong. The work was the kind he'd been gravitating toward naturally, family office restructuring for a multi-generational wealth management situation. So the kind of problem that required both forensic analysis and the more architectural creativity of designing new structures to replace the ones that had broken. He was good at it. He found it interesting in a way that felt genuinely rather than professionally, which had always been for him the distinguishing test. He was in Singapore on a Tuesday. It was the second week. The work was in a productive phase, and the kind of middle period where the problems were clear enough to be solvable and not yet so clear as to be mechanical. When he had dinner with a colleague, a woman named Sable Kwan, who ran a boutique advisory firm in Seoul that overlapped with his work in a few specific areas. They'd corresponded professionally for 2 years and met twice before at conferences. She'd asked him, over the second glass of whatever the restaurant had recommended, how long he'd been in Zurich. What he'd said 14 months. She'd said she'd been in Seoul for 11 years and was thinking about moving. Not because of anything wrong, just because 11 years in one city started to feel like a kind of certainty she wasn't sure she'd earned. He'd said he understood exactly what she meant. She'd looked at him in a way that registered his meaning and didn't immediately perform a response to it. And he'd found that specific restraint, that willingness to receive what was said without immediately converting it to something else, more interesting than he'd been prepared for. They'd talked for 3 hours. About work, mostly, the specific problems they were each finding interesting, the structural approaches that were evolving in their respective practices, the particular ways that family wealth behaved differently from institutional wealth and required a different quality of attention. And about other things. She'd grown up in Busan and had an older brother who was an engineer and a father who'd been a fisherman and who'd told her once that the ocean was honest in a way that made everything else look like a performance. Marcus had said, "That's exactly the right way to describe it." She'd smiled, and it was a specific kind of smile, not the social kind, not the performance kind, but the kind that meant something had landed. They'd said good night at the restaurant door, him shaking hands in the professional way that had no weight other than its own correctness, and walked in different directions into the Singapore night. On the flight back to Zurich 3 weeks later, over the dark of the Indian Ocean with the cabin quiet around him, Marcus had thought about the dinner, and about Sable Kwan, and about the particular quality of a conversation in which both people were speaking directly and receiving directly, and neither was performing anything for the other's benefit. But he'd thought about what it would mean to build something again with that quality of material at the foundation. He'd thought about this for a long time, with the patience and the professional honesty that were the 2 things about himself he was most certain of. And when the cabin started to lighten with the Eastern approach, and the flight attendant came around with coffee, he accepted the cup and looked out the window at the edge of the morning coming up over the Arabian Peninsula, cold and definite, like a deadline that had nothing to do with failure and everything to do with what came next. He drank the coffee. He opened his laptop. He began to work. Reese called him on a Thursday in November, a year and 4 months after the Connecticut house had emptied, a year after the civil judgment, 8 months after the sale had closed, and said, "I heard from Daniel's attorney. He's proposing a settlement on the outstanding judgment balance." "How much?" $200,000. "Your cash, immediate transfer, structured as a full and final settlement." The remaining balance was $391,000. The proposed settlement was $200,000. The gap was $191,000. Marcus thought about it for approximately 15 seconds. "Tell them 190, he said. "Full documentation of all assets disclosed in the discovery process, certified under penalty of perjury as a condition of settlement. And a clawback provision if any undisclosed asset is identified within 5 years. The clawback provision will be the sticking point." "Yes," Marcus said. "That's why it's in there." There was a brief silence. "You think he has undisclosed assets?" "I think a man who embezzled $108,000 over 22 months in amounts specifically calibrated to avoid detection thresholds had a reason to believe he'd need a reserve. And I think the reserve existed before I found the embezzlement. I think it's been very carefully positioned." He paused. "The clawback provision is the instruction to whoever advises him next that I am watching." Reese was quiet for a moment. "I'll transmit the counter. One more thing. I want the settlement document to include a non-disparagement clause covering both my name and my firm, and a specific provision that he is prohibited from characterizing the partnership's performance or dissolution in any professional communication without express written consent." "That's unusual." "He's in the advisory business," Marcus said, "or he was. The version of this story he might tell to rehabilitate his reputation includes a version of me that I won't allow to circulate." "I understand." Another pause. "Marcus, are you—" "I'm fine, Reese. I'm better than fine. I just want this closed with the correct architecture." "Right." He could hear the smile in Reese's voice. "I'll call you when they respond." He ended the call and stood at the window. The Zürichsee in November was doing what it always did in November. Contracting, going quiet, holding its cold surface with the patience of something that understood its own seasons. He watched it for a while. He thought about the house in Connecticut. Empty now for a different reason. Sold, as occupied by people he didn't know, holding whatever new specific human claims they'd made on its space. And he thought about the shelves he'd built there, and the coffee they'd made, and the documentary about deep-sea architecture, and all the small, genuine textures of a life that had been real while it was happening, and that he did not need to have been wrong about. It had been real. It had also been finished. Both things were true. Or he thought about Sable Kwan and the ocean being honest and a specific kind of smile. He thought about Singapore and the work he was doing that he found genuinely interesting, and the apartment in Seefeld, whose floors were slightly too light and whose window now faced the view. He pulled out his phone and opened the contact he hadn't yet used. He typed, "I'm going to be in Seoul in February for a week. If you're free, I'd like to finish the conversation we started in Singapore." He looked at it for a moment. Then he sent it. He put the phone in his pocket without waiting for a response, because the correct move, when you'd committed to a position after due consideration, was to stop watching the position and start doing the next thing, and went back to the desk and opened the client file and found his place in the work and continued.
sector. Move to defensive positions.
I don't know if I can play like this. The headphones. I can't. Wait, how do you have an ad? You're subbed.
Okay, listen up, team. I have eyes on the hostile snipers. What's the location?
I can't hear shit like this.
Hostiles have breached the sector. Defend our objectives.
Now Dell XPS one? Are you talking like, are you gotta be lying to me. We're gaming now, boys. Ask me about my wiener. Oh, okay. That makes sense. This is really... I don't know if I'm gonna be able to do this. I can't hear anything.
Hostile casualties are being reported.
'Cause I don't know how... Because my headset is wired. I mean, I guess I could... pull it up through the floppy wiener part.
We need to defend the marked objective.
Attack is underway on Bravo.